Kia ora, this is the final video to cover the missing part of the lecture from the 14th of October, where the recording didn't pick up the final part of the lecture well enough. So this is looking at the defence of withdrawal. This also, of course, is covered very thoroughly in the case of arson, which is in your reading list. So it's important for you to remember that the defence of withdrawal is a defence that relates to sections 66 subsection 1 and subsection 2, and that is because party liability is derivative liability, so the secondary party is able to withdraw from their role in the offending provided they can undo their participation in the offending before the offence is committed, or before the offence is attempted. So it was considered quite extensively in the Supreme Court judgment of arson, as it was a defence run by the two women. Now, in the majority judgment of arson at 118, the Supreme Court did recognise that withdrawal is a defence under the common law that is still preserved by Section 20 of the Crimes Act, and therefore it remains available. And the rationale for the defence is that it may actually prevent the commission of the offence and thus avoid the harm caused by the offending, either by dissuading the principal from committing the offence or being frustrated by the secondary party's withdrawal, that the principal offender is unable to commit the offence. But it also provides people with an incentive to withdraw, so an incentive to change their mind and take steps to then prevent the crime from happening. But as you will see, it's a very strictly applied defence. It's very rarely successful. And what is done to withdraw and the timing of that withdrawal is important to the success of the defence. Now, arson makes it clear that there are two requirements for the defence of withdrawal to succeed. First, there must be conduct, either by words or actions, that demonstrate clearly to the others involved in the offending, whether it be other secondary parties or the principal or principals, that the secondary party is withdrawing from the offending. And secondly, that the withdrawing party must take reasonable and sufficient steps to undo the effect of his or her previous participation, or depending on what the nature of their role has been, prevent the crime from happening. And it is this second requirement that is most often problematic in succeeding in the defence. The second requirement is very much a factual inquiry. This was made clear by the Supreme Court in arson at 135. And in deciding whether or not the defence of withdrawal is successful, the court will consider what is reasonable and sufficient in the circumstances of the case, with particular consideration given to the nature and degree of the assistance and encouragement provided by the secondary party seeking to withdraw, and the timing of the attempted withdrawal in relation to the perpetration of the offence. So how close to the commission of the offence was the withdrawal attempted, and what was done to actually withdraw. And what is done to withdraw must be proportionate to the impact of the offence, the impact of the assistance earlier given. So what that means is that if you either have done a lot to either aid or abet or assist in the commission of the offence, then it is going to be much harder for you to withdraw, or you're going to have to do much more to be considered to be successful in the defence of withdrawal, because the assistance or aid provided in the commission of the prosecution of the common purpose of the commission of the offence must be proportionate to the aid and assistance provided. And the court said at paragraph 136 of the arson judgment, they talked about when looking at the nature and extent of the party's involvement, when communicating discouragement or dissuasion to the principal offender. So what we're looking at here is where the person has actually encouraged the offending, then that discouragement or dissuasion to the principal offender can be either oral or in writing, but provided there's sufficient clarity and communication, then that may be enough to actually undo or be capable of undoing the influence of previous party conduct, which consisted solely of words. Now, you'll remember, well, I'm hoping you'll remember, that when you encourage, as a secondary party under section 661, when you encourage someone in the commission of the offence, all that is needed is that the person actually hears your encouragement or is aware of your encouragement if it is done by conduct. The person doesn't need to actually commit the offence as a result of your encouragement. There is no need for that level of connection between the encouragement and the commission of the offence. But in what the Supreme Court is suggesting here is saying capable of undoing the influence of previous party conduct seems to suggest almost that you have to undo any influence that you had, even if there was no influence in the first place. So even though they're talking about proportionality, it does raise the question of whether or not if you've just communicated encouragement, even if the person wasn't encouraged, do you then have to do more than that and dissuade the person and discourage them from committing the offence to be successful in the defence of withdrawal? Again, we're still looking at section 136, but when looking at the party's previous participation, if they're looking at actions of assistance, then further reasonable steps to undo that previous assistance will then require someone to prevent the crime for there to be a valid withdrawal. So such steps may require, for example, retrieval of a weapon provided, or a warning to the victim, or contacting of the police. So where you're looking at the impact of earlier assistance and withdrawal, it must be proportionate, it must be clear, and you must, where you've provided actual assistance, then you must undo what you have previously done to assist the person in order for you to be successful. And obviously the timing of that withdrawal is going to be very important as to whether or not you can be successful in the defence of withdrawal. So if you do them at a preliminary stage, then, and if what you've done is very little, then you've got much more likelihood of succeeding in the defence of withdrawal. The closer you are to the commission of the offence, or the more that you have done to actually either assist or encourage, or particularly where you've joined up to a common purpose, then it is going to be much more difficult for you to then withdraw and communicate your withdrawal and then undo what it is that you need to undo in order to succeed. In the case of arson, this was a good example where there might not have been a great deal of assistance provided by the two women. By the time the person conveyed that they no longer wanted to be involved, and this was particularly in relation to the driver of the vehicle, who you may recall pulled up alongside the victim, and when the victim tried to get in the car, all four of them jumped out, but she had driven them to the location where the offence took place. It was then impossible for her to undo the assistance that she had in fact provided at that time, because the offence was already occurring, and two, how could she undo delivering them to the place where, or driving them to the place where the offence actually took place. So she placed them in the position for them to be able to commit the offence, and it was then at the time that she tried to withdraw, too late for her to do so. So it's important to remember that when you are looking at your factual inquiry, that the timing of withdrawal is important, and that the person must not only convey with their words or their actions that they are seeking to withdraw, if they've done some form of assistance, or if they have done something to encourage, then they must discourage or they must undo that assistance, and that will not always be the case. So in terms of party liability, I'm hoping what you the takeaway here is that if you end up in a situation ever where people are talking about doing something really stupid, at that very early point, it's very important to convey that you do not agree with the action that is to be taken. Choose your mates wisely, and get out of the situation immediately, having made it very clear that you do not want to be involved. Because as you will have seen, and as we talked about in the lecture, party liability is a very broad application of the law. Withdrawal as a defence is very difficult to prove, and this net of liability is spread currently quite wide. So that is the end of the lectures on party liability. I will obviously be posting these. I'll put up another announcement regarding further office hours next week, but if I don't hear from any or many of you, then please do your best in the exam. Best of luck, and it's been an absolute pleasure teaching you this year.